Okay, well, thank you very much for joining us. My name is Ian Scott, and I am the founder of Scott Legal. Today, we are going to spend some time taking a look at the E-2 visa requirements, and we're also going to take a look at what it's going to take to renew an E-2 visa after you get it. A few things before we get started. Some of you are aware that our firm, Scott Legal, was founded on an E-2 visa around 10 years ago. We've renewed the visa once already, and we are going to renew again this year. So if you have any specific questions about the getting the visa or the renewal process or my own personal experience, I'd be happy to share that information with you. The firm Scott Legal is a full service immigration firm, but we focus on E-2 visas. And in particular, we do a lot of E-2 visas where they are higher risk. So the investment amount is lower or there are other risk factors. We processed hundreds of E-2 visas at consulates around the world. And two of the consulates that we tend to focus on are London and Toronto. In terms of webinars, we will continue this webinar series. We have at least 2 webinars a month. We have another webinar on investor visas coming up on February 21st. We'll put a link in the chat box as well so that you can sign up for that webinar. That webinar will go over E-2 visas. It will go over EB-5 visas. It'll go over the International Entrepreneur Program rule, and it will also go over the National Interest Waiver, which is another popular green card option for investors. In terms of after the presentation, we're going to send you a number of different things. We're going to send you the PowerPoint presentation that we're going to go through. We're going to send you an E-2 visa guide. It's a comprehensive visa guide that goes through a lot of the information that we're going to go over today. We're going to send you a link where you can sign up for additional webinars. And we're also going to send you a link to this video. And because this is being recorded, and when we send that link, we're actually going to send it as a YouTube link because we do turn these webinars into YouTube videos after. And when you do take a look at that, you can actually sign up, you can subscribe on our YouTube channel because we do, in addition to the webinars, we do post a number of different immigration specific videos to the actual YouTube channel. In terms of our the panelists today, you're going to have myself. I've already introduced myself, and we have Dustin Saldarriaga. Dustin is a fellow Harvard Law School graduate, and he is an associate at the firm, and he has processed a number of E-2 visas himself. And in terms of questions, if you do have questions, you can either add the questions to the chat box or you can put them in the Q&A. Yes, so without further ado, I will turn it over to Dustin to go over the first few slides.
Perfect. Thank you so much, Ian. And it's a pleasure to be with all of you for the presentation. Thank you for joining us. So we're going to start off this presentation by going over the fundamental E-2 rules, requirements, and regulations. And then we will switch a bit more into the renewal aspect. What should you have in mind when you go up to renew your E-2 visa? So the E-2 visa is a treaty investor visa. We'll get into what that means in a moment. It is a non-immigrant visa, which means that it does not directly lead to a green card. If you're interested in that topic and how many of our clients do eventually use an E-2 visa to leverage their green card applications, we do have a separate webinar on that topic. And so please do check out our YouTube channel or sign up for that webinar to learn more. But the E-2 visa is a non-immigrant visa, meaning that when you apply for it, you must have the intention to leave the United States at the end of your E-2 status. The E-2 visa allows nationals of certain countries to come to the US to develop and direct the operations of an enterprise in which they have invested. So the E-2 visa, if someone's eligible for it, we really do see it as one of, if not the best option for a foreign national to come to the US to build their business. It's a great option for foreign entrepreneurs. So options for obtaining an E-2 visa. Obviously, like I said, for entrepreneurs, you can have a startup. You can use an E-2 visa for a startup. You can also purchase an existing business and use an E-2 visa to come to the US to develop and direct that business that you've purchased. Or another option is to start a franchise. And that tends to also be a fairly well-worn path that is quite reliable because consulates like to see franchises since they have track records. There's a little less uncertainty there about whether this is a business that is actually going to generate revenues and employ people. Now, I've said a couple times that an E-2 visa is a treaty visa. What that means is that for someone to be eligible for an E-2 visa, they have to have a passport from a country that has a certain treaty with the United States. We call these E-2 treaty countries. And there are over, at this moment, I think there are over 80 countries around the world that are E-2 treaty countries. And the way you can find them is if you Google US Department of State treaty countries, you'll get a long list, and it actually says which countries are E-2 countries. And if you have a passport from that country, that's really the only requirement to meet this nationality requirement. Even if you're a dual national, if you have a passport from a treaty country, you would qualify. The exception is if you're a US citizen or a permanent resident of the United States, you wouldn't qualify. But as long as that's not you, and you have a passport from a treaty country, you satisfy that requirement. And a common question we get is, for how long is my E-2 visa valid? And this really depends on something called reciprocity. The United States has essentially agreements, whether formal or informal, with E-2 treaty countries that influences how long the visa is valid for. The maximum period of time that an E-2 visa would be valid for is 5 years. And what I mean by that is when you go to the consulate and you get the visa in your passport, the validity period is 5 years, meaning you can enter and exit the United States for a 5-year period. Each time you enter the United States, you're given 2 years of status. Status is different from the life or validity period of the visa. So if you have a visa that's valid for 5 years, and you enter the United States on the last day of that 5-year period, you should get 2 years of status in the United States, assuming that your passport is valid for that period. That's the difference between the visa validity period and status. So you get 2 years of status when you enter the US on an E-2 visa. The visa itself is at most issued for 5 years. The visa can be issued for as little as 3 months. Some countries do have reciprocity agreements with the United States that shortens that validity period of the visa to 3 months. Again, if your visa is valid for 3 months, you should get 2 years of status when you enter the US on that visa. Now, the validity period does influence to some degree whether we would recommend that you apply through a consulate or domestically with US Citizenship and Immigration Services. If you're already inside the US and you have the citizenship of a country that has 3 months of reciprocity, that might weigh in favor of instead applying through USCIS and getting 2 years of status, but that's really case specific. And related to that, I should say that having a visa, obviously, like I said, does give you the ability to enter and exit the US. Having status does not give you that ability. So if you're in the US, say visiting on a B1 visa, and you decide to apply through USCIS to change your status to E-2 status, and let's say you're approved and you're given 2 years of E-2 status, once you leave the United States, you would not have an E-2 visa to enter the US unless you've applied for that at a consulate. So that's an important difference between status and a visa. So let's get a bit more detail on what the E-2 visa requirements actually are. The first requirement, in addition to being a national of a treaty country, is that you must make an investment into the E-2 business. Funds that you invest into the business must be what is called at risk. And what that means is that the funds have actually been spent. In contrast to, say, transferring funds to a business bank account, it's not enough to simply have, say, $1 million and to transfer that money to a business bank account in the United States and say, that's my investment. The government actually wants to see that those funds, or a substantial part of those funds, have been spent on the business. And the government uses this as a kind of a litmus test to see how committed is this applicant to the business. Keep in mind, the government, they're not typically business people. They're not typically accountants or CPAs. And so even if it's not necessarily a good or a wise business decision to spend a lot of money on a business at the start, the government's not thinking about it that way. The government, for better or for worse, is thinking about the investment amount as really a test of the applicant's commitment. Have they put enough money on the line that if I give them this visa, they're probably going to take it seriously and actually build this business that they say they are? So the money that's invested in the business can be from any legal source. The test for this is really legality. The government wants to see, were the funds lawfully acquired? Very common sources of income that we see with our clients are from work. We would then in the application include tax records and pay stubs showing that that the applicant actually legitimately earned these funds from work. You can also use a gift. Could be a gift from a family member, a friend, an associate, anyone. We would include a letter that explains the gift from the person giving it. And we would also include documents from that person that explains how they got it. So if they earned it from work, we would include their tax records, for example. Common sources of funds also include the sale of a significant asset, could be the sale of a house or the sale of an investment property. And we would, of course, have to have documents there that show that you actually own the property, the deed to the property, and documents showing the sale of it and the transfer of funds to your own account. From there, and for any of these sources of income, we'd also want to show that the funds traveled from that source of income to the E-2 business. So oftentimes what that looks like is the applicant's personal bank account statement that shows incoming funds, and then transfer receipts or the same bank statements often that show the withdrawal of funds and their arrival into the E-2 business account. Or if the E-2 business doesn't actually have a bank account already set up, then proof that the funds have been spent. So that could be bank statements showing withdrawals to a certain company that sold goods that are needed for the business, or a credit card statement, for example. And we'll talk more about that investment requirement. The investment amount must be substantial, and that's a word that the regulations use. There is a lot of uncertainty about what substantial means. What does the government mean when it says substantial? Because the government actually doesn't give a dollar amount. There is no concrete dollar amount that's sufficient for an E-2 investment. But what the government does say is that the investment amount should be proportional to the type of business in order to get it operational. And that's really the lens through which we look at one of our clients' investment amounts. The first question is, what kind of business are they starting? If it's a manufacturing business, then more money is required to start the business. If it's a service business, like a law firm, then less money is required to start the business. And so from there, we really ask the question, okay, given that, say, for example, it's a law firm and less money tends to be required, has the applicant spent enough money to show the government that the business is ready to be operational? We might, to show that, we might include trade publications that talk about the usual amount of money that's required to start, say, a law firm. We might also, if this is a startup, we might also get a CPA certification, where a CPA, a public accountant, would sign a statement that says, I've looked at the amount that's been invested in this business, and based on my professional and expert opinion, this would be sufficient for a law firm to get started, for example. The other important aspect of the investment amount is that it's not only the total amount of the investment. The government also wants to see that money has been spent on the variety of things that are needed to get the business started. So going back to my earlier example, obviously, if $1 million were transferred to a business bank account and sat there, they're not committed. But similarly, let's say that $1 million was spent to buy an office space, and that's the only expenditure for the business. The government would have an issue with that, because the government will say, well, have you actually spent money to market the business? Have you actually spent money on furniture, on equipment you need for the business? If it's a business that will sell products, have you purchased inventory? The government wants to see that when you're issued the visa, you're ready to come to the US and to hit the ground running and get this business generating revenue and hiring workers. All right, moving on to the Roman numeral 2 here, the business cannot be marginal. This is a key requirement for an E-2 business, is that it must employ US workers. It's not necessary for the business to employ US workers at the time of application. It is necessary for the E-2 business to employ US workers within the first 5 years of operations. And usually our guidance is within the first 5 years of operations, the business should employ between 3 and 5 full-time equivalent US workers. So what that means is if you have 6 part-time workers, they could be 3 full-time equivalent. But that's really, within the 5-year period. The earlier you can start that process, in general, the stronger the application will be. So if you can show the government, right now I don't have workers, but in year 1, I'm going to hire a worker. And by year 5, I'm going to have 3 full-time workers. Generally, that would be sufficient. But again, key requirement, you must show that you'll hire US workers. And oftentimes in consular interviews, and throughout the application process, it's helpful to keep in mind that at the end of the day, what the government is wanting to see is that this is a business that will generate sufficient revenue to hire US workers. So keep that in mind as you're developing your business plan or as you're looking for a business to purchase in the US. The business must be real and operating. I touched on this before, and the way I like to think about that is once the visa is issued, the applicant is essentially ready to show up in the US and start generating revenue. So if there are any significant obstacles to that, for example, if you are starting a medical practice and you need to have a certification from the State Department of Health where you'll be operating, it's important to get that before you apply, because if you show up at your interview and you explain what you're going to do and the consular officer asks, well, do you have the necessary licenses? And you say no, that could destroy the application and result in a denial. So you want to get everything in line before you apply to show that the business is ready to be operational. And all that needs to happen is for you to get your visa, hop on the flight, and show up in the United States. Pieces of evidence that we usually include in an application to show that a business is real and operating is that we would often include a signed commercial lease, show evidence that the business has been established. That could be the state where you incorporate or organize the LLC. You have documentation showing it's been organized, screenshots from a website, contracts that you have with customers, evidence of licenses that are required, things along those lines. The other requirement, number 4 on this list, is that you must be coming to the US solely to develop and direct the E-2 enterprise. This can get a little bit tricky if you're applying through USCIS domestically and you're providing professional services. For example, if you are starting an accounting firm and you are an accountant, it's very important for you to show, again, if you're applying through USCIS domestically, that you will be primarily developing and directing the business and not providing direct services to clients. And again, that's an issue that's largely limited to USCIS. If you're applying at a consulate, it's less of an issue. Still important to keep in mind that your role really does need to be to grow and manage the business. You're not coming to the US to provide direct services to individuals necessarily. You really are here to grow the business. And that's tied to the marginality requirement where you need to hire workers. If, for example, you find that you're in the position of the accountant who, it's an early stage startup, you're an accountant and you're going to be providing these services, how do you get around this obstacle that you're really not supposed to be the one providing accounting services? The answer is to hire as early as you can and show the government, I already have at least a part-time accountant who's working and they will be providing the direct services to clients. My role will be supervising them, reviewing their work, and really growing the business. Number 5 on the list, and this also is really a threshold issue along with nationality. If you don't have nationality, the nationality of a treaty country, You don't pass stage one. If you don't have 50% ownership in the E2 business, you also don't pass stage one as an E2 investor. Um, you may have the option to apply as an E2 employee, but that is a separate discussion. And if you're in that situation, please feel free to reach out and we can talk separately. But to apply as an E2 treaty investor, you must own at least 50% of the E2 business. It's fine to have shared ownership with someone. So 50-50 owners are perfectly fine. It doesn't matter who your co-owner is. As long as you own 50%, it's okay for your co-owner to be a US citizen, a permanent resident, a citizen of a non-E2 treaty country. The important thing is that you have that 50% ownership in the country, in the company. And finally, related to the E2 visa being a non-immigrant visa, you must have the intent to return to your home country upon the expiration of your E2 visa. So usually to show this, the requirement is minimal. We include in our applications a signed statement from the applicant that simply says, my name is Dustin, I'm applying for an E2 visa, and my intent is to leave the US at the expiration of my visa, signed Dustin. Usually that's sufficient. And in our experience, that usually doesn't raise any issues. Okay, I am going to pass it back off to Ian to talk about what a sufficient investment amount is.
Excellent. Thank you very much, Dustin. And that was a great explanation of the requirements. And I think that one of the biggest or the most frequent questions that we receive is, how much do I have to invest? And I think Dustin already did a great job describing kind of things to consider when you're looking at the investment amount in terms of, what type of business is it? And if it's a business that's service oriented business, it might be less. If it's a business that requires more to get started, it's going to be more. But I think that, a couple of just takeaways when you're looking at investment amount. So the first takeaway is that even though a service oriented business, you could spend $3,000 and get a service oriented business up and running. In some cases, you may just need a laptop and a desk, and that's all that you need. Despite the fact that that type of business only requires a low investment amount to get started, that's not going to be enough for an E2 visa. The consulates in particular are going to want to see, that you've spent money. And generally, we say, like in our engagement letter, when we send it to you, we have an estimate that we say that generally speaking, even for a business like a service oriented business, we suggest that you spend at least $40,000 and then put aside money as working capital. Now, we have done many cases where the investment amount has been a lot less. Our own firm, we only invested $15,000 and had a little bit of money in a bank account, maybe 35,000. So the total investment was 50,000. It was approved, and we've done other applications like that since. But the fact is that when the investment amount is low, the case is a riskier case. And we say that to clients, and sometimes I'm not sure they understand that riskier case means higher chance of denial. Right, that's what it means. That's just what it means. So when we're dealing in E2 visas, where our firm has an approval rate of around 98% with respect to E2 visas, and although past results don't predict future outcome, most E2 visas are approved, right? But when you are looking at the 2% or when you're looking at denials, and we're going to talk about this a little bit later in the presentation, one of the key reasons that E2 visas are denied are low investment amount, right? So that's always something that you have to consider. Now, the other big thing to consider with investment amount is that it's where you apply. So depending on which consulate you go to, or whether you're applying through USCIS is going to be fine with a very low investment amount, even as low as $25,000, they're going to be fine. Certain other consulates might be fine with a lower investment amount, like Toronto or London, if you have other factors. But then there are some consulates that that would laugh you out of the consulate if you went to them with an investment of under $100,000. So you do have to when you're hiring an immigration attorney, you have to hire one that kind of understands the what's going on in different consulates, or is able to reach out to others who have filed recently in particular consulates, and so that you do have a good sense. Now, the final point with respect to kind of how much to invest is, a lot of clients they just want an app. They want a number, right? They want like, give me the numbers at 30, 40, 50, 60. But I always try and move them away from that, and indicate to them that the investment amount is just one thing. So for example, when I invested a very small amount in my business, the examiner was very taken by the fact that I had a lot of business experience, the fact that I had a Harvard Law School degree, that I'd recently written a book, like all of these reasons that the examiner thought that I was going to be able to turn a business into one that could hire US workers. Now, so what I mean by that is that the overall strength of your case is going to impact whether or not you can, let's say, get away with a small investment amount. We had a doctor once, and she was treating patients for a neurological disease, disorder rather, and she had contracts from insurance companies showing that the company was going to make lots of money. She had the professional qualifications, and she invested, and this was recent, she invested less than 20,000. If you spent less than 20,000, but we were always confident that that application would be approved because there were so many other positive factors in her case. So the positive factors are, it could be your educational background and experience. It could be that you've already hired employees. It could be that you have proven success. Like if someone has a company that they're running in their own country and they've hired employees, it could be proven success that they've already done it once. So the government's going to think that they could do it again. It could be that, franchises automatically increase the percentage chance of approval. If you're buying a business, that's very positive for approval, because if you're buying a business that already has employees, we had someone who spent $60,000 on a pizza business, and it was easily approved, even though that's still a relatively low investment amount. So the key thing to take away is you should move away from the what is the number, right? Because I think that it always depends, and the number is, like if you could go to a lawyer and the lawyer says, well, two extremes, right? The lawyer says it has to be $100,000 or you're not going to get approved. That's clearly wrong, right? I'm living proof that that's clearly wrong. But the other, on the other side, if you go to a lawyer that says, "Oh, no problem, you just invest $10,000 and you'll be fine," you should shy away from that as well, because it really is going to depend on all like those factors that I just went over. Um, and I think Dustin, did a great job explaining the kind of the proportionality test already. But but if you are doing a need to with something that's under $300,000, you should invest the full 100%, right? That's if you're doing a need to where it's $10 million, maybe you can invest 7 million or 6 million or something like that, and it would still be considered substantial. One of the things that we tend to do if the number is low, and we don't tend to do this, we're very strategic on how we do it, but we do sometimes get CPAs to write letters to say that the applicant has spent everything that's required for this particular type of business. I know Dustin mentioned as well that we sometimes get business articles to say that this is how much this particular type of business costs to get started. But the CPA letter is very compelling because it says that the CPA has gone through their business plan, has gone through their expenditures, and has written a letter. And we have a standard kind of wording that we try and get the CPA to follow, but ultimately is the CPA's letter. And that can be very helpful at some consulates, not all consulates, but some consulates, in particular consulates that aren't familiar with E-2 visas and or USCIS. But if it's a consulate like London or Toronto, they're not going to pay much attention to the letter at all. They'll make the assessment, a CPA letter at all. They'll make the assessment themselves, whether or not the investment is substantial. Toronto, I would go as far as to say they would completely ignore a CPA letter. So in terms of when you're buying a business, the reason we kind of put this up here, like if you're buying a business, the investment amount is just going to be the purchase price, and that's going to equal the fair market value, because it's basically, between parties that don't know each other, then, that what you pay for it is what it's worth. I think that where this comes up is sometimes an issue, though, is if you're buying a business from a relative, or you're buying a business where there are kind of suspicious circumstances around how you're getting the business. We just had a client that hired us they filed on their own, and they received an RFE, a request for evidence, from USCIS. They were doing a change of status, and one of the biggest issues, it was they purchased something, and one of the biggest issues in the RFE was that the examiner was not convinced that it was an arm's length purchase or real purchase, right? So when you're purchasing from family members, that's something that you can, and you will talk about reasons for this a bit more in the reasons for denial. I mentioned already, franchises are great, E2 visa investment options, and sometimes if you do a franchise, maybe you can decrease the investment amount. In terms of investment items, Dustin went through a number of them, but I think I want to focus on the bad ones, right? Like bad E2 expenditures are travel, entertainment, food. We have people that include receipts for Chipotle and McDonald's and taxi rides and different things like that. Government is not going to pay any attention to them, and they can even kind of hurt your case because the government might think that you're reaching. Some consulates explicitly say on their website that they don't like expenditures like that included. And if a few consulates have that on their website, that means that other consulates don't like it either. They just haven't put it on their website, right? But definitely, the expenditures should be expenditures that are directly related to setting up the business. So, not your education. We can go back and say, okay, well, my investment wasn't 15,000. I spent, 200 grand to go to law school. So can I include that as the investment? It doesn't work that way, right? Like, it's things that are directly related to your investment that can be included. Another kind of questionable expense is often cars, right? Like, someone who has a consulting business and they say that they need a car for it. Well, that's not typical. Even the IRS has issues with making deductions with cars. They make you go through extensive documentation. So if the car is relevant for the business, or a vehicle is relevant for the business, if you have a home renovation business or something like that, then certainly that's something that can be included. But if not, the government may just think that it's a personal expense, and the fact that you may use it to go back and forth to work doesn't mean that it's an investment for the way that the way examiners would see it. So the next, I think Dustin did a great job as well going through this. The whole E-2 visa is all about employees, right? The only reason this visa exists in the United States is because it has to do with hiring employees, the economic benefit of hiring employees. So that's what you're trying to do. So that's when you hear it, it's referred to as this marginality requirement. But all that really means is that the government wants to see that you're going to be hiring employees. And we typically do this through, if it's a new business setup, you definitely need a business plan. The business plan has to have 5 years worth of financial projections. It has to have an income statement, balance sheet, cash flow statement showing that the business is going to grow. We do offer the service of drafting business plans. So with an E2, that is a separate service that we offer. But the plan does have to be comprehensive. And really, you want to be showing that at the end of 5-year period that the company is going to be in a position to hire 3 to 4 full-time employees. So it could be, and those are full-time equivalent. So it could be part-time employees, combination, like 2 part-time employees that work 20 or 17 hours a week would be considered one full-time employee. If you already have employees when you're applying for an E2, that's fantastic. It's great. Either employees or 1099 workers, contractors, that's fantastic. It really helps your case. And we would include the W2s. W2s, the name for the form that is issued to an employee at the end of the year. So the W2 show how much the employee made, but and 1099s are to contractors. So including those in the file are great. And the other thing that we do is to show that you're going to be able to hire employees is we will include documentation showing that you have contracts or letters of intent that show that your business is going to be more viable. Because if it's just an idea, sometimes that's going to be a little bit more difficult to get traction when you actually go to the consulate. And if you're purchasing an existing business, then in that case you're not going to need a business plan. Instead, the government's going to be much more interested in actuals. So they want to see tax returns for the last few years, and then the W2s to see who the employees are. If you're buying a business, you should buy a business with 3 full-time employees already, at least 3, the equivalent of 3 full-time employees. If you don't, you're at a starting point where you're trying to prove to the government that that you will ultimately hire employees. And because I had a consultation just the other day with someone, and they want to start a convenience store, or I think a relative wants to buy a convenience store, and the convenience store only has one person working there, right? So one or one and a half people working there. So that's going to be an uphill battle from day one. Whereas if the business had three people working there, then it would be an approvable E2 on day one. And keep in mind that the employees, it doesn't matter how much they make. They don't have to be managerial. They could be making minimum wage. It does, none of that matters. The headcount, if E2 visa had one employee making $200,000 a year after 5 years, but then another company had three employees that were making, $25,000 each a year, like if they were getting minimum wage in Florida, the second company would be approved, where the first one might not be, right? So the amount or the levels of the people for E2 does not matter. Some visas it matters, not this one. So. Business plan considerations. I'm not gonna spend much time on this slide, other than to say you do need a business plan in the situation where you're starting a business. And as I said, if the business has been around for a couple of years and it's profitable and has employees, then you don't need a business plan. If it's not profitable or it doesn't have enough employees, then you still would need a business plan in that instance. And the slide just goes over the key areas of the business plan. We have a lot of really good guidance on our website. There's a business plan page on our website that we'll actually put it in the chat for you to take a look at. And but it has all of the sections that you would look at, and it has a number of different articles on business plans as well. So we will put that in the chat. And the other thing we'll put in the chat is the details related to the webinar that we're going to have on February 21st on investor visas. Perfect. Dustin, I can't remember. Is this mine? This is my slide, right?
I think it was. I'm happy to jump in.
Okay, no, that's fine. No, it's fine. No, it's fine. No, I just couldn't remember. So E2 visa adjudication trends and development. So a few things here. So one, the last administration introduced Buy American, Hire American policy, which for the first time, even though the regulations indicate that investment doesn't have to be made in the US, there was more of a focus on making the investment and the purchases in the US. That, has lightened a little bit, but we still do advise clients that, the majority of the expenditure should be made in the US to strengthen your application. Another trend we're seeing is something called administrative processing, and it is bad. Like, we're seeing it a lot. And for, before we understood the reasons we saw it, like we had an E2 that we filed in London, and then the person went into administrative processing. And then later, when they asked for the 15 years of security data for the person, we saw that before that, he worked at a tobacco company, and he used to travel to a bunch of different countries around the world that the US was not as friendly with. And that's why they put him in administrative processing, and it cleared, and he got his visa in a month or so. However, we're just seeing a lot of people that go into administrative processing, and what happens is they sit there for 2 or 3 months, sometimes even more, when the government does their security checks. So it is something that we are seeing much more in the last year and a half than I would say even than during the last administration. And I'm not really sure what the reason is for it, because we're not, when people do fill out the security information, we're not seeing anything where we say, oh yeah, I understand now why that happened. So the other trend is definitely more USCIS filings, because consulates are delayed, still backlogged. So people want to start their business. Some in London and Toronto, you're going to wait 6 months before you get your interview. So sometimes people come to the US and file with USCIS, even though USCIS has a lot of shortcomings. In terms of the impact of the Biden-Harris administration, other than the things going into administrative processing, I don't know if that has to do with the administration or just different security flags. It could be security flags that were brought in from the last administration, because the last administration introduced a bunch of more security questions, social media requirements, and different things like that. So I don't know if those things are just flagging people more to go into administrative processing. But all of those administrative processing cases, almost all of them or all of them, have been approved ultimately. It's just a time burden. And then finally, COVID-19 issues, lots of them. The consulars delayed, still much better than before, but as I said, some consulates 6 months, some even longer. And then also the other kind of big thing is testing and vaccines. Like, you have to understand the US requirements and the requirements of the country you're coming from. You can, in Canada, you can't leave Canada unless you're vaccinated, right? So, so that's going to be hard to enter the United States, whether you have a waiver or not, right? It's the same thing with the states. The states requires a number of different things to be able to enter the US. They require a vaccine, and there are very few exceptions with respect to it. And there's a medical exception, but definitely you have to look at it. Also, testing requirements are constantly changing, so definitely you have to look at that, both in terms of when you're going to the country to do your interview and when you're returning to the US, because we had one client that went to Italy, and although the government of Italy had a rule that you had to quarantine when you got there for, I don't know, 5 days or something like that, the consulate in Italy, in Rome, said that they had their own rule that said that anyone who comes into the country has to quarantine for 14 days before they come to the consulate. And so this person came 7 days before, in accordance with the Italian law, and he wasn't able to go to his interview. And don't rely on your lawyer to check that kind of stuff. We don't, they don't have we certainly don't, and any lawyer you use won't have the ability to understand the changing requirements in the multiple consulates around the world. So it is something you have to check. And as I said, it's constantly changing in different places, right? So Canada, I think, just recently introduced something for March where Canadians that are returning no longer have to do a PCR test; they can do a rapid test. So things change all the time, right? So definitely keep your eye on this. So this we're going to run through pretty quickly, but I think Dustin did a great job already describing source and trail of funds, in particular for USCIS filings. So when you have to show where the money came from, and that can often be the most significant thing when you're doing a USCIS filing. When you're doing a consular filing, we don't pay a lot of attention to source and trail of funds. We include some information, but not much. Like, we go in very, very light, and often because the client has the ability to explain it to the consulate. So that's better. With USCIS, there's no interview or anything like that. Loans for an E-2 visa are fine as long as they're not secured by the company assets. So that usually precludes or excludes rather the seller financing arrangements, or arrangements where someone, it's asset heavy and then there's a mortgage, because in those cases the business is actually the security. And gifts are also fine for E-2 visas. Given the shorter duration, it's not as bad as EB5, where they have time to look at gift tax and different things like that. Small investment amounts, I think we talked about that a lot already. E-2 investors for two visas, visas for two investors rather. E-2 visas for two investors. This is something, it's definitely possible. I think that if you are doing this, you want to invest more. Like, so if, let's say that we say 40,000 was the number for one investor. If it was two investors, you want to increase that maybe to 80,000 or 70,000 or something like that. But just more. We have a case we just recently did, which had two investors, where the amount is very, very low. So that's going to be a test case, but it's with USCIS. So we might see, we might, we may, it might be fine, but definitely that will be a test case, because that would probably be the lowest we've ever done if you split the amount in two. Substantial changes after business filing. This comes up a lot. People, they start a consulting business, and then they have their LLC or their corporation. They say, oh, I don't want to do that anymore, and then they just start a restaurant, right? You can't do that, right? Yeah, you can do it, but you have to, there are things you have to do, right? When you have the visa for what it is you say that you're doing. If there's a significant change, then you have to report that. If it's a minor change, maybe you don't have to report that, but you definitely want to kind of work closely with your immigration attorney to kind of go through. And we talked already a little bit about this, the family business purchases, and how this can be an issue. We had a case that was approved in Australia. The case was approved. Even we gave a lot of warnings. The case was approved. The person was buying something from a brother-in-law. It was approved. 4 years later, the person went back to renew in Australia, and then the examiner raised the issue about the familial relationship and denied. He said it should never have been approved in the first place, because the examiner just felt that the money was kind of just all floating around family, and he just didn't feel the money was at risk. So definitely something, it can work, but you just have to be very, very careful And it took 4 years to catch up with this person because we warned the person from the beginning that this could be an issue, but it just happened that it wasn't an issue when they first went.
Great, thank you, Ian. So
Thank you.
we are going to kind of continue what Ian's what was just talking about and focus on some common reasons for E2 denials. And again, a number of these we've touched on throughout the presentation. A very common reason for an E2 visa denial is the low investment amount. This could be either that a low amount has actually been spent, or that there is a large amount sitting in a bank account that hasn't been spent. So again, important to spend enough to make the business operational, and ideally to pair that with evidence that ideally you've already started employing people, or have a really strong business plan to show how the money you've invested is going to lead to employment very soon. Another common reason for an E2 denial is the nature of the business. And we haven't touched on this very much, but there are certain types of businesses that tend to be more passive rather than active businesses. And again, if you recall, one of the E2 visa requirements is that the applicant must be coming to the US to develop and direct the business. Part of what that means is that the business actually needs to be active. This can't be a passive investment. So real estate, you see real estate on the screen. The government does tend to scrutinize businesses that are focused on real estate investment, flipping homes, things of that nature. And really what the government wants to see is that this business, even though there is passive investment in the sector, in the real estate sector, that instead this E2 business is going to be one that actually does employ people to do the work, and where the applicant is going to really need to play an active role in developing and directing the business. So if you are in real estate investment, if you are in even general financial investment, then it's especially important to work with a lawyer to figure out how to shape the application to kind of address preemptively any concerns that the government might have. The filing location and venue also has sometimes a lot to do with a denial. So Ian mentioned before, certain consulates do have more strict requirements, for example, when it comes to the investment amounts. Just as a quick example, Japan actually, I believe they are still the country with the highest number of E2 visas approved. Japan's, many E2 visa holders are from Japan, both now and historically. And so the consulate in Tokyo tends to see established businesses that are sending either investors or employees to the US. So when they get an application where someone has invested less than 100,000, it could be riskier than if that application were sent to, say, Toronto, where we have many clients who are entrepreneurs who go to Toronto, and it's a venue where, in contrast to Tokyo, it tends to be less strict about the investment amount. One thing I will note is that USCIS. So USCIS, is where you would apply for a change of status if you're already in the US. USCIS tends to look less at the overall investment amount in comparison to consulates. So whereas consulates would want to see, in general, a larger amount, and it's a real risk that a low investment amount could result in a denial, USCIS, while that's still important, would tend to be more forgiving of a lower investment amount as long as it's sufficient to make the business operational. In contrast, at USCIS, they are essentially going to do a financial audit of where the funds came from. So a consulate would spend less time on that aspect of the application. So you can start to see that if a client comes to us and says, I've invested a low amount, but I have really good documentation about where that money came from, that might weigh in favor of applying through USCIS versus a consulate, for example. The next two items on the list are closely related, and both get to this concern of whether the US business will actually employ workers. So if an application is from an applicant who has already started this type of business in their home country, and that business has not employed workers. That is understandably going to raise questions at the consulate, where they may say, well, you want to start the same business in the United States, yet when you did this before, you didn't employ workers. Why should I believe that when you do it in the United States, you are going to employ workers? It's not, an obstacle that you can't overcome. You would just need to be very thoughtful, probably especially in the business plan, to explain how you're going to do things differently in the US, whether it's you're pivoting your service offering or your product offering, you're going to focus on marketing in a new and unique way. And making things concrete is always important. So if you can show, hey, I know that when I did this business in Canada, I didn't employ anyone, but look, in the US, I've already employed a worker. So this is going to be different. There's little that's more persuasive than that, than actually showing that the business is actually employing someone. So issues with an adjudicating officer, this is kind of the wild card in the equation. Consular officers have essentially complete discretion when it comes to deciding whether to approve or deny an application. Frankly, even theoretically, even if you satisfy every requirement, an officer can say, I just don't feel right about this one, and deny it. And there are rogue officers who do that. They are, believe it or not, in our experience, they tend to be rare. Consular officers do tend to be reasonable. And when we pull together an application, we try to think about it through the eyes of the consular officer, because that's what really matters. In the end, what matters is whether they approve your application. So by and large, we find that officers are reasonable and understand, how we frame things in the application. But just to be aware, consular officers do have discretion and sometimes do unpredictable things. And finally, if an application does not meet the requirements at the time of filing, then it's not going to likely be approved. And so it's really important to think about, as you prepare an application, every single aspect of what is required: nationality, investment, marginality, employing workers, and showing that your business really does satisfy those requirements. And in this final slide, I'll quickly talk about what it takes to renew an E-2 visa. And really, I think Ian and I have both set up this slide because everything we've talked about before is relevant when you're renewing an E-2 visa. Hiring US workers is key. If you have had a visa for 5 years and you still don't have employees, that is a critical issue when you go to renew your application. So in the period when you have your initial visa, focus on hiring at least 3 to 5 full-time equivalent US workers. And as Ian mentioned, salary doesn't matter. So, if you're starting an accounting firm, say, and you have an accountant, you don't have to hire 2 more accountants necessarily. You could hire an office manager. You could hire someone who focuses on marketing, someone who focuses on billing. So you can think creatively. You can hire a security person. You can hire and someone who cleans the office. That's okay. And a lower salary amount is fine. It doesn't have to be, the government's not going to say, well, this employment's more important because you're paying more. When you apply for a renewal, provide updated financial data. You'll want to show tax returns for at least the last 2 years, showing that this is a company that generates revenues to a degree that you can employ workers and have done that. You'll want to show that the targets that you laid out in the initial application were hit, or you substantially made progress toward them. So a lot of people, a lot of our clients, ask the question, well, if I show a projection that I'm going to hire 20 workers and I only hire 15, is that going to result in a denial when I go to renew? The answer is probably not. The government really just wants to see that you are employing, again, at least 3 to 5 workers. But if you don't have to inflate the projections, it's better to take a conservative approach. Really, in your initial application, put in numbers that you're pretty confident that even if the next 5 years are bad years, you're pretty confident you'll be able to hit those. And then it's easier to show the government when you go up for your renewal, hey, I've actually surpassed my projections, rather than having to explain to them why you missed the projections. In a renewal, going back to employment, you'll definitely want to include W-2 forms, which is the tax form for employees, and 1099 forms, which are the tax records for independent contractors. And related as well to the initial application, when you go for a renewal, it's important to show that your plan was effective to increase business volume and really put you on the trajectory to accomplish what you aim to accomplish. If the company is not doing well, you'll definitely want to show that there is a concrete plan to hire employees. Again, if you haven't done this in the period when your initial visa was valid, this can again result in a denial when you go to renew. But if you're in that last year, year 4 of your 5-year visa period, and you only have one employee, focus on hiring. You really want to boost that number before you go for the renewal. And finally, Ian touched on a couple of these points. When you go for a renewal, it's important to show that you still meet the threshold requirements for the visa, specifically ownership. So if your ownership stake drops below 50%, you immediately become ineligible for the E-2 investor visa. So you want to make sure that you've maintained at least 50% ownership in the business. As Ian mentioned, it can be okay in some circumstances if the focus of the business changes. For example, if you are operating a restaurant and you decide to open a smoothie branch, that is clearly related to the business. But if your E-2 application is for a restaurant and you decide to start a business that consults on let's say internet networking, installing internet in businesses software, that could be a problem because the two businesses are not clearly related. So you want to make sure that the type of business that you presented to the government for your initial application has not changed substantially. And if it has, definitely work with a lawyer to figure out if there's a way to kind of frame the application to show that the two are actually more related than it might appear, although that's not always something that can be overcome. So we have just a few minutes, and I know that Ian has been responding to some of the questions.
Yeah, and I can just run through because I think I've answered most of them, the ones that were in the Q&A, but I've taken a look at the other ones, so let me just run through them quickly. And some of these were in the Q&A as well. The first question is, if you own 25% of 2 franchise stores, would that be 50%? The requirement is based on an entity, right? So you have to own 50% of an entity. The next question, so if I bought a cleaning company for I imagine $50,000 and have 50,000 in the bank for running costs, will it be kind of good? I'm in Australia. I think that would be fine if you bought something for 50,000 that had employees and you had 50,000 in the bank account. I think that would be fine. My company investment will be 100K, but I'm personally investing only 50K, and the other 50 is from my partner, which is a company from another country. So that could be fine. It could be structured so that it's fine, so that if your other partner owns 50%, you own 50%. You've invested 50,000 and your other partner invested 50,000, that could be fine. Can the spouse of an E-2 visa holder be sponsored an EB3 visa through an employer? The answer is yes. There's more to the question, but we're running out of time, so I'm just going to say the answer is yes if he or she meets the requirements. Okay, so then is the E-2 visa doable? No, I think is the E-2 visa dual intent visa? No, it's not. It's a single intent, but they do not require, the regulations don't require that you sell your home. So there's a little bit more flexibility than say a B1, B2. Can an E-2 visa holder work for his company and while on the E-2 status process an EB3 with an employer? Yes, that can be done. If it's separate employer, not your company, but if it was a separate employer, that could be done. So if buying an existing and profitable business, which already has 2 to 3 full-time workers, doesn't require a business plan, I would say if it has 3 full-time workers, it wouldn't require a business plan, and the workers could not be family members. So it couldn't be the owner and their family and different things like that. But if you if you have tax returns that show profitable business with at least three employees, I would say that for 2 years you would not need a business plan. We have to renew our E2 this year. We're from Germany. Do you see the possibility of getting an extension in the US due to COVID? Yeah, absolutely. If you meet the renewal requirements that Dustin went over in the last slide, that would certainly not be a problem. Renewing in the US so that you don't have to go back to Germany, and then you could plan to go back to Germany when when you're more comfortable going back. My visa expired in June 21st, I-94 valid until June 23rd. No more employees since pandemic, 2 contractors. Okay, my business is a franchise. Do you think, well, I think if you don't have employees, I didn't go through it in detail, but I think if you don't have employees, I think it's going to be difficult to renew the E2 visa. You can, a lot of the time, if someone doesn't have employees and we try to make the argument anyway, we look at what there is, if we can provide explanation, etc. So I'm just going to run through the last couple of questions quickly because we do have to cut off right at 10 today. Hello, is lower than 50% stake for the applicant? Sorry, it just jumped.
I'm sorry, Ian, I typed the answer.
Oh, okay. No, it's okay.
I
No,
didn't
that's
realize
fine.
you were
Well,
reading.
no, that's
The
fine. No,
answer is
that's
no.
fine. No, the answer is no. Okay. Is the USCIS the right department for this extension? That's right. It is USCIS. If you're doing an extension in the US, it's a form I-129. When to start an LLC and all process. Okay, you should start basically when's the best time to do an E2 visa. The best time to do it is at the apply for the E2 visa right when the business starts, because then they can look at business plan or projections rather than actual. So the last question is, I'm a Canadian national currently in Seattle on a pending TN implied status. Hence, I cannot leave the US at the moment. Could I still apply? Well, yeah, you could apply it. You could apply in Toronto because when you're called for the interview, you have to go for the interview. So if you didn't get your TN approved, and you could always upgrade your TN to do premium processing, because if you needed an answer sooner, you can certainly do that. It's available. Premium processing is available if you filed in the US, or if you're Canadian, there's no need to premium process. You can just go leave the country and re-enter. Okay, great, perfect. So thank you very much, everyone. It was great. Great, speaking with all of you. As I said, we're going to send out the PowerPoint presentation. We're going to send out, this is going to be recorded. So we are going to send out a link to the YouTube channel, the visa guide. And, we're also going to send out information on how you can set up a consultation with us if you would like to do that. Again, I encourage you to sign up for subscribe to the YouTube channel, as we have many of these. Thank you very much, Dustin, for your insight today, your great insight today, and looking forward to interacting with you all at some point in the future.
Thank you so much.
Thank you. Okay, thank you. Take care. Bye-bye.